Welcome to the Spiggle Law Firm podcast, where we help people who've been fired or afraid that they might be. I'm Tom Spiggle, host of the podcast and founder of the Spiggle Law Firm. Today, I want to be talking about another reason why people don't get the legal help that they need in the employment context. In the last podcast, I talked about how people incorrectly believe they cannot win a he said, she said contest. Not true. The second one is the belief that because you live in what we call an at-will state, that you can't bring a successful claim against your employer. Before we get started, a few housekeeping matters. This podcast is not intended as legal advice for you. If you want specific legal advice about your case, then you got it. You should go hire a lawyer. All right, well, let's jump in. So I have seen any number of times people say, whether it's on our social media posts or otherwise, well, you can't win that case, or I'm not going to bring a case because I live in an at-will state. So let's define what at-will means. Almost every state in the United States, except Montana, I don't know if there's another one, but are at-will states, which essentially means that you can be fired for any legal reason. The key word being legal. It also means that you have no obligation to your employer. If you want to quit a job, you're not required to give any notice. It's an at-will state. Of course, it's best practices to give your employer some notice if you're going to quit, but you don't have to. Your employer can't turn around and sue you and say, well, you didn't give me 2 weeks notice, because it's an at-will state. Similarly, an employer can fire you for any legal reason. I don't like people that wear blue shirts. Well, I'm not going to hire people that wear blue shirts. I have a policy that everybody in the office has to be in at 9:30 sharp, and you are late, 3 days in a row in violation of the policy. Even though you have a good reason, I can legally fire you. You're in sales and a new manager comes in and he incorrectly calculates your conversion rate or other sales metrics, and so you get put on a performance improvement plan. That's not illegal. Employers are entitled to be wrong as long as they are not discriminatory. On the flip side, if your employer does something that is illegal, it doesn't matter if you're in an at-will state. Every client, and we represent hundreds of clients a year, every client that we have that walks through our doors is in an at-will state. I mean, we are primarily in Maryland, Washington, D.C., and Virginia, and all those three states are at will. But these folks have successful claims, because if you violate a law, a state, a federal, or local law, as an employer, you can be successfully sued for that. It doesn't matter if you're an at-will state. It's not a get-out-of-jail-free card. So if you're a boss, let's say you get pregnant, you've been doing everything has been fine before you got pregnant, and then all of a sudden you start getting negative performance reviews even though you're not doing anything different, and then you get fired. Well, that's certainly evidence that you were fired on the basis of your pregnancy. And if you have 15 or more employees, which is the threshold requirement for the big federal most anti-discrimination laws, if your employer has more than 15 employees, then that's illegal. Doesn't matter if you're in an at-will state or not. Let me also define another term that gets sometimes mixed up here, and that is a right-to-work state. So a right-to-work state is different than at-will. Right-to-work applies to union membership. So if you're in a non-union shop, or your matter doesn't involve a union, it doesn't matter if you're in and I put in air quotes, right to work state or not. A right to work state, and there are probably, 10, 15 states, mostly in the South and some in the Midwest, that are right to work states. And that essentially means that you can't be required to join a union if you join that employer. And you may say, well, that seems fair. Why would you force somebody to join a union? And the reason is that the union represents everybody. And when they go to bat for the workers and get higher wages or better working conditions, that applies to every employee that is in that job site. And so the argument on the other side is like, it's fair then, if the union is going to represent everyone, that everyone be required that everyone support that union. But in a right to work state, that's not how it works. You can join a union, a place that is unionized, and you cannot be forced to join that union or to support it. So that's right to work. But again, that has no bearing whatsoever on an individual employment case. Union, non-union, if your employer discriminates you against you on the basis of race, religion, national origin, disability, pregnancy, then you're going to have a case. Again, assuming the employer is large enough. And that includes state laws, because there can be overlapping state laws. There can be even local ordinances that may apply. Again, doesn't matter if you're in a right to work state, doesn't matter if you're in an at-will state, doesn't matter if you even know what those things are. If you've got a claim, you've got a claim. Employers are not entitled to violate the law, and they don't get a get out of jail free card just because they're in a state that has one of these labels. And again, almost every state in the nation is at will. So don't let that stop you from going to see a lawyer. Now, you may or may not have a case, and it may or may not be worth bringing, but don't let it stop you from getting the help that you need just because you erroneously heard from somebody, well, it doesn't matter. You can't sue your employer because you are in an at-will state, because that's simply not true. All right. I hope you found that helpful. If you did, please share this podcast with somebody who could also use some of these lessons. We would appreciate it. In the meantime, best of luck out there, and we'll talk to you guys later.